We're back on the record. State of Ohio versus Lindsay Partin. CR 2018-03-0462. It appears all attorneys are present, all parties are present. Ladies and gentlemen of the gallery, of the public, we'll make some comments before we bring the jury out. I do not have the verdict forms. I do not know what these verdicts are. I'm going to caution you, you are still under your admonitions. Whatever these verdicts are, I will not tolerate outbursts, emotional displays. You see all these deputies here. Any emotional outbursts from anybody, you will be immediately removed from this courtroom and this building. Hope that's clear. Ms. Wilson, parties, are you ready to bring the jury out?
Yes. Yes, Your Honor.
All right, let's go ahead and bring the jury out. All right, everyone have a seat, please. Ladies and gentlemen of the jury, we are on the record. It is the court's understanding that we do have verdicts on this case. Who is my foreperson?
I am, Your Honor.
Sir, is my understanding correct? We do have verdicts reached in this case?
Yes, Your Honor.
All right, Ms. Wilson, would you please go collect the verdict forms from our foreperson? While we're doing that, ladies and gentlemen, I want to thank you for the time, the attention that you have put into this case. I know it's been a long process, probably a tiring process, but I do appreciate your dedication to trying to seek the truth in this matter. I want to take a moment to review these. And based on my review, the verdict forms appear to be consistent verdicts. Ms. Partin, if you and your attorneys would please stand. Jury verdict form 1. As to count 1 of the indictment, endangering children in violation of Ohio Revised Code section 2919.22, subsection B2. We, the duly impaneled jury, do find the defendant Lindsay Partin guilty. And there are 12 signatures reflecting that verdict. As such, pursuant to the court's instruction, Form 1A was not used. Jury verdict Form 2. As to count 2 of the indictment, endangering children in violation of Ohio Revised Code section 2919.22, subsection B3. We, the duly impaneled jury, do find the defendant Lindsay Partin guilty. And again, there are 12 signatures. Jury verdict Form 3. As to count 3 of the indictment, endangering children in violation of Ohio Revised Code section 2919.22, subsection A. We, the duly impaneled jury, do find the defendant Lindsay Partin guilty, with again 12 accompanying signatures. Special verdict Form 3. As to count 3 of the indictment, endangering children in violation of Ohio Revised Code section 2919.22, subsection A. We, the duly impaneled jury, having found defendant Lindsay Partin guilty, do further find the offense did result in serious physical harm, accompanied by all 12 signatures. As to count 4 of the indictment, involuntary manslaughter in violation of Ohio Revised Code Section 2903.04, subsection A. We, the duly impaneled jury, do find the defendant Lindsay Partin guilty, accompanied by all 12 signatures. Jury verdict form 5. As to count 5 of the indictment, endangering children in violation of Ohio Revised Code Section 2919.22, subsection B1, we, the duly impaneled jury, do find the defendant Lindsay Partin guilty with 12 accompanying signatures. Special verdict form 5. As to count 5 of the indictment, endangering children in violation of Ohio Revised Code Section 2919.22, subsection B1, we, the duly impaneled jury, having found defendant Lindsay Partin guilty, do further find the offense did result in serious physical harm. This is accompanied by 12 signatures. And finally, verdict form 6. As to count 6 of the indictment, murder, in violation of Ohio Revised Code Section 2903.02, subsection B, we, the duly impaneled jury, do find the defendant Lindsay Partin guilty. All 12 signatures accompany the verdict. Ms. Partin, you and your attorneys may have a seat. Defense, would you like the jury polled?
Absolutely.
Ms. Wilson, I can't find my seating chart. All right, ladies and gentlemen of the jury, when I call your juror number, I'm going to ask you if these reflected your individual verdict, and you will respond that it either did or did not. So I'm going to start in the front row at the far left, juror number 717. Do these reflect your verdicts?
They do, Your Honor.
Juror number 829, do these verdicts reflect your verdicts?
They did, Your Honor.
Juror number 236, do these reflect your verdicts?
They did, Your Honor.
Juror number 197, do these reflect your verdicts?
They do, Your Honor.
Juror number 102, do these reflect your verdicts?
They do, Your Honor.
And juror number 43, do these reflect your verdicts?
They do, Your Honor.
Top row, far left, juror number 2.
They do, Your Honor.
Thank you, ma'am. Juror number 621, do these reflect your verdicts?
They do, Your Honor.
Juror number 751, do these reflect your verdicts?
They do, Your Honor.
Juror number 951, do these reflect your verdicts?
They do, Your Honor.
Juror number 434, do these reflect your verdicts?
They do, Your Honor.
And finally, juror number 872, do these reflect your verdicts?
They do, Your Honor.
All right. Having polled the jury, ladies and gentlemen, again, I do thank you for the time that you have put into this. We have went about 12 hours today. I know that you're probably tired, would like to get out of here. Because of the nature of this case and because of certain other issues, what I'm going to do is I'm going to dismiss all of you back into the jury room. Got a few things to handle out here. We're going to make sure, the deputies are going to make sure that the galleries and the public and everything that, gets dispersed and whatever, and then you'll be able to leave the building with the deputies accompanying you. Okay? So at this time, ladies and gentlemen of the jury, again, I thank you for your service. You obviously are discharged from your admonitions. You are free to discuss this with whomever you want, or you are free to discuss it with nobody. That is completely your business. The attorneys may wish to speak to you after we get done here, even though it's a late hour. If you don't wish to, you don't have to, but again, that's your choice. So again, ladies and gentlemen, the notepads and everything, we'll take care of destroying the notes, we'll take care of putting it back here, don't worry about that. Thank you so much for your service. Ms. Wilson, if you would like to leave the matter. All right, everybody be seated, please. Ms. Partin, I am now going to give you an advisement as to what a recent change in the law has been termed as Sierra's Law. I'm required to give you this advisement. We are going to subsequently set a separate date for sentencing, even though we do have a mandatory sentence associated with the murder because of Sierra's Law, and also to give people opportunity, victims' families, defendants, anybody that wishes to speak when we come back for sentencing. I do wish to make sure that we devote sufficient time before that. So, Ms. Partin, because you have been convicted of murder, the law presumes that you must now register as a violent offender. You have the right to file before or during sentencing a motion to rebut that presumption. If you do, you would have to prove by a preponderance of the evidence that you are not the principal offender of the offense. If you cannot prove that, you will be required to enroll on the violent offender database once a year for 10 years. And that's after you, if you're released from prison, because you're dealing with a 15 to life sentence, that would take place after you're released from prison. If you can prove that, the presumption will be rebutted and we will have a separate hearing. I will consider if you have prior convictions for any offense of violence and whether those convictions indicate a propensity for violence. I will also consider a risk assessment test. I will consider your culpability or involvement in the offense. I will finally consider the public interest and safety. As a result, I can still order you to register for 10 years, or I can order you that you are not required to register for those 10 years. Do you understand what I've just advised you? And Ms. Howard, I don't know what your intentions would be in terms of filing that motion. If you believe that you might file that motion, then I would ask the probation office to get me a risk assessment. But that's something you can let me know at a future time.
Thank you, Your Honor.
With that, the next thing that's going to happen is I'm going to set a sentencing date. If everyone has their calendars. Since we're going to be coming back for separate sentencing, even in light of the mandatory sentence associated with count 6, I would ask that all attorneys prepare to address any issues of potential merger and allied offenses that might apply in this case, so everybody can have the opportunity to be heard accordingly. Let's see, today is April the 12th. I know we may, because we're dealing with so many attorneys, we may have to take a few shots at getting this set up. First date that I'm looking at would be Tuesday, May the 14th. I can set that either morning or afternoon. I can set it for as long as the attorneys feel would be appropriate. Again, because of the magnitude of this case, I do not want to rush the sentencing hearing.
The state is available, Your Honor.
I have a trial that day.
How about the afternoon of May 13th, Monday the 13th? And Ms. Began, I don't know when your trial started, so.
I can't do the 13th.
Okay. How about, does anybody have any availability the week prior? May 7 or 8 or 9 or 10? I can fit in a hearing for however long we would need on any of those days.
The state's available.
Well, May 8th.
I have a trial on the 8th. I can't do the 8th.
But the 7th.
I can't. I can do the morning of the 9th. Can you do the morning of the 9th?
I'll make it work.
State?
Yes.
All right. I'll set this matter then, Ms. Hiley, if you can get us a scheduling order. Thursday, May 9th, 9 o'clock. I'm going to block off all of my morning, and, you know, if we use an hour, if we use whatever, you know, again, I don't want anybody to feel like this hearing is going to be rushed. So the defense is aware of what's coming up next. I know this has not been discussed. Since we do have a mandatory sentence associated with count 6, my inclination at this point is going to be to revoke bond and take your client
Yeah, I
into
understand.
custody. I understand there have been no issues while she's been out on pretrial, but at this point, with what the anticipated sentence is going to be, I am going to go ahead and do that. Okay?
Yes.
So, Ms. Partin, you are going to be taken into custody at this point. Is there anything else we need to address before we come back on May 9th?
Nothing on behalf of the state.
The only thing that I can think of is that the Sierra law was enacted after these offense facts, so there might be an issue of constitutionality and retroactivity that we'll have to litigate. on
Well,
that
you'll
particular
probably end up litigating at a higher court than us.
Right.
The law, as it has been drafted and has come out, has made it applicable to people that are currently, right now, even in prison,
I
long
understand.
before this passed.
issue. The only reason I brought it up is because it might affect your scheduling, like if we do briefs.
No, like I said, I'm setting it for all that morning. You guys submit your briefs, I'll let you argue whatever points you want to argue, and then we'll go from that point, okay?
Sounds good?
All right.
I just really have to, I understand.
If there is nothing else to address then, this part will be taken into custody, we will be adjourned for the evening. And deputies, I would appreciate a expeditious evacuation of the gallery so we can take care of the jury. Okay? And folks in the gallery, tough case. Believe me, I'm not without feeling in that regard. For whatever it is worth, I do appreciate that you did keep the emotions in check. And I do have feelings for both sides in terms of knowing that you guys, both families in this are hurting. And so I get that. But I do appreciate your keeping your composure. We'll go off the record and that'll be it.